All rise, we would have. The international residual mechanism for criminal tribunals is now in session. L'audience mécanisme international appelé à exercer la fonction résiduelle de tribunaux pénaux et ouverts. Please be seated.
Madam Presiding Judge, we are experiencing a technical difficulty at this end. Could you kindly pause until we rectify the issue? Thank you.
Looks like the technical problem has been resolved. We are now proceeding. Good afternoon, ladies and gentlemen. There is an echo. As some of us are participating in through a video connection, I would like to emphasize that only the person, excuse me, there is an echo that follows behind what I say. Why is it on? Okay, let's try again. They want me to read. Sure, put it back. Good afternoon, ladies and gentlemen. As some of us are participating in this hearing through a video conference connection, I would like to emphasize that only the person who is speaking may have their microphone turned on. All others, kindly keep your microphones off until such time as you are invited to speak. Thank you for your cooperation. We will now proceed. Registrar, please call the case.
The Appeals Chamber of the International Residual Mechanism for Criminal Tribunals, sitting in The Hague this 8th day of June 2021, in the matter of the prosecutor versus Ratko Mladić, case number MICT 1356A, Judge Priska Nyambe presiding.
Thank you. Mr. Mladić, can you follow the proceedings in a language you understand?
Mo.
Thank you. Let me now ask for the appearances of the parties. First, before turning to counsel for Mr. Mladić, I note that the defense has informed the appeals chamber that due to medical reasons, Mr. Dragan Ivetic, co-counsel for Mr. Mladić, is unable to participate in the proceedings today. We wish him a good and speedy recovery. Furthermore, at the request of the defense, the appeals chamber has exceptionally granted the right of audience to legal consultant, Miss Peter Louise Bagot, for the pronouncement of judgment. Now, counsel for Mr. Mladić.
Madam Presiding Judge, Your Honours, good afternoon. Peter Louise Baggett for Mr. Mladić.
Thank you. In accordance with the scheduling order issued on 30 October 2021, and pursuant to Rule 144D of the Mechanisms Rules of Procedure and Evidence, the appeals chamber will now pronounce the judgment in the case of prosecutor versus Ratko Mladić. I will first summarize the essential issues on appeal and the central findings of the appeals chamber, and will then read the disposition in full. This oral summary does not constitute any part of the official and authoritative judgment of the appeals chamber, which will be distributed in writing to the parties at the close of this hearing in confidential and public redacted versions. From 27 September 1965 until 10 May 1990, Mr. Mladić was a member of the Yugoslav People's Army and held various positions in military posts throughout the former Yugoslavia. On 12 May 1992, the Bosnian Serb Assembly appointed Mr. Mladić as a commander of the main staff of the Army of Republika Srpska, and he remained in command until 8 November 1996. On 24 July 1995 and 16 December 2011, the Office of the Prosecutor of the International Criminal Tribunals for the former Yugoslavia filed respective initial and operative indictments against Mr. Mladić, charging him with individual criminal responsibility on 11 counts of genocide, crimes against humanity, and violations of the laws or customs of war under Article 3, 4, and 5 of the Statute of the ICTY, covering crimes allegedly committed between 12 May 1992 and 3 November 1995 in Bosnia and Herzegovina. On 22 November 2017, Trial Chamber 1 of the ICTY acquitted Mr. Mladić of genocide under count 1 of the indictment in relation to crimes committed against Bosnian Muslims and Bosnian Croats in certain municipalities throughout Bosnia and Herzegovina. The trial chamber convicted Mr. Mladić pursuant to Article 7.1 of the ICTY Statute of 1. Genocide, 2. Persecution, extermination, murder, deportation, an inhumane act as a crime against humanity, and 3, murder, terror, unlawful acts on civilians, and taking of hostages as violations of the laws or customs of war. The trial chamber found Mr. Mladić responsible for committing these crimes through his leading and grave role in 4 joint criminal enterprises. That is to say, 1, the overarching JCE, aiming to permanently remove Bosnian Muslims and Bosnian Croats from Bosnia's Serb-claimed territory in Bosnia and Herzegovina between May 1992 and November 1995. 2, the Sarajevo JCE, aiming to spread terror among the civilian population of Sarajevo through a campaign of sniping, shelling between May 1992 and November 1995. 3, the Srebrenica JCE, aiming to eliminate the Bosnian Muslims in Srebrenica between July and at least October 1995. And 4, the hostage-taking JCE, aiming to capture UN personnel deployed in Bosnia and Herzegovina and detain them in strategic military locations to prevent the North Atlantic Treaty Organization, NATO, from launching further airstrikes against Bosnian Serb military targets from May to June 1995. The trial chamber sentenced Mr. Mladić to life imprisonment. Mr. Mladić filed an appeal challenging his convictions and his sentence. He requests that the trial chamber reverse all erroneous findings of the trial chamber, quash his convictions, and acquit him. In the alternative, Mr. Mladić seeks a retrial or a reduction in his sentence. The prosecution filed an appeal challenging some of the trial chamber's findings pertaining to the overarching JCE and its acquittal of Mr. Mladić for genocide under count 1 of the indictment. The prosecution requests that the appeals chamber correct the trial chamber's errors and convict Mr. Mladić of genocide under count 1 of the indictment. The appeals chamber heard oral submissions of the parties on 25 and 26 August 2020. I now turn to Mr. Mladić's appeal. A, fair trial rights. In grounds 1, 2A, 8A, 8B, and 8D of the appeal, Mr. Mladić submits that the trial chamber violated his fair trial rights by 1, relying on incidents which were not part of the indictment or the prosecution's case in determining his liability. 2, taking judicial notice of adjudicated facts relating to the conduct of proximate subordinates and heightening the standard of the burden to produce rebuttal evidence. 3, failing to ensure equality of arms in relation to the presentation of the defense case. 4, conduct trial proceedings to the detriment of his health and failing to assess the impact of his medical conditions on his behavior at trial. 5, failing to provide an adequate remedy for the prosecution's disclosure violations. For reasons stated in the judgment, the appeals chamber finds Judge Nyambe dissenting that Mr. Mladić fails to demonstrate that the trial chamber committed any error in these respects and dismisses ground 1, 2A, 8A, 8B, 8D of Mr. Mladić's appeal. B, the overarching JCE. The appeals chamber recalls the trial chamber's finding that between 1991 and 30 November 1995, the overarching JCE existed with the objective of permanently removing Bosnian Muslims and Bosnian Croats from Bosnian Serb-claimed territory in Bosnia and Herzegovina through the crimes of persecution, extermination, murder, inhumane acts, forcible transfer, and deportation. The trial chamber further found that Mr. Mladić's acts and omissions were so instrumental to the commission of the crimes that without them, the crimes would not have been committed as they were. The trial chamber concluded that by 12 May 1992, Mr. Mladić significantly contributed to the overarching JCE and shared the intent to achieve its common objective. Under ground 3A, Mr. Mladić submits that the trial chamber committed several errors in finding that the overarching JCE existed and that he was a member of it. Having considered his submissions, the appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić has failed to demonstrate that the trial chamber committed any error in its method of relying on adjudicated facts when making findings on the underlying crimes of the overarching JCE. The appeals chamber also finds, Judge Nyambe dissenting, that Mr. Mladić fails to demonstrate any error in the trial chamber's assessment of the evidence which he purports to be exculpatory relating to membership relating to his membership in the overarching JCE, as well as in his assessment of the scope of the joint criminal enterprise, his relationship with the Bosnia Serb leadership, and his role in the PRS. Therefore, the appeals chamber, Judge Nyambe dissenting, dismisses ground 3A of Mr. Mladić's appeal. Under ground 3B, Mr. Mladić argues that the trial chamber erred in finding that he significantly contributed to and intended to participate in the overarching JCE. In addressing Mr. Mladić's challenges, as detailed in the judgment, the trial chamber finds, Judge Nyambe dissenting, that Mr. Mladić fails to demonstrate that the trial chamber erred in finding that he significantly contributed to the common criminal purpose of the overarching JCE. In relation to Mr. Mladić's submission that the trial chamber erred in determining that he possessed and shared the intent to achieve the common objective of the overarching JCE, the appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić does not demonstrate that the trial chamber erroneously applies a defective method in determining his intent. Similarly, the appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić failed to demonstrate any error in the trial chamber's assessment of direct and circumstantial evidence, contrary to his argument that the trial chamber selectively relied on parts of his speeches before the Bosnian Serb Assembly to substantiate his intent. The appeals chamber finds, Judge Nyambe dissenting, that the trial chamber took a balanced account of his statements in their context and considered them within the totality of evidence of all his statements and conduct pertinent to the overarching JCE. Furthermore, Based on the trial chamber's finding and assessment of evidence, the appeals chamber finds, Judge Nyambe dissenting, that the alternative Mr. Mladić proposes, namely that he only sought legitimate military success rather than permanently removing Bosnian Muslims and Bosnian Croats, is not reasonable. The appeals chamber, therefore, finds, Judge Nyambe dissenting, that Mr. Mladić demonstrates no error in the trial chamber's finding that he shared the intent to achieve the common objectives of the overarching JCE. Based on the foregoing, the appeals chamber, Judge Nyambe dissenting, dismisses ground 3B of Mr. Mladić's appeal. C, the Sarajevo JCE. The appeals chamber recalls the trial chamber's finding that the Sarajevo JCE existed between 12 May 1992 and November 1995, with the objective to spread terror among the civilian population of Sarajevo through a campaign of sniping and shelling, including through commission of murder, terror, and unlawful attacks against civilians. The trial chamber determined that Mr. Mladić shared the intent to further and significantly contributed to achieving the Sarajevo JCE common purpose. Under ground 4A of his appeal, Mr. Mladić challenges aspects of the judgment in relation to the crime of terror, whether Sarajevo was a defended city, the existence of the Sarajevo JCE, as well as his participation and intent. As elaborated in the judgment, the appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić failed to demonstrate that the trial chamber erred in exercising jurisdiction over the crime of terror, or that there are cogent reasons to depart from established jurisprudence in this respect. Furthermore, the appeals chamber considers, Judge Nyambe dissenting, that Mr. Mladić does not demonstrate that the trial chamber erred by finding to consider Sarajevo as a defended city, and finds that Nyambe dissents that Mr. Mladić fails to demonstrate that no reasonable trier of fact could, in principle, have concluded that terror was the primary purpose of the shelling and sniping of the campaign in Sarajevo. The appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić also failed to demonstrate error in the trial chamber's assessment of his statements and orders, especially given the totality of the factors relied upon by the trial chamber in the overall assessment of his intent in relation to the crimes committed within the Sarajevo JCE. Furthermore, the appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić fails to demonstrate that the trial chamber applied an erroneous standard of proof or erred in its assessment in finding the perpetrator's specific intent to spread terror among the civilian population of Sarajevo. For the foregoing reason, the appeals chamber, Judge Nyambe dissenting, dismisses ground 4A of Mr. Mladić's appeal. Under ground 4B of his appeal, Mr. Mladić challenges the trial chamber's assessment of the majority of incidents which considered to form part of the Sarajevo crime case. The appeals chamber finds, Judge Nyambe dissenting, that Mr. Mladić does not demonstrate that the trial chamber failed to consider evidence of legitimate military activity, erroneously relied on adjudicated facts, failed to provide a reasoned opinion, or erroneously inferred the responsibility of the Sarajevo Romania Corps of the VRS. Therefore, The appeals chamber, Judge Nyambe dissenting, dismisses ground 4B of Mr. Mladić's appeal. D. The Srebrenica JCE. The appeals chamber recalls the trial chamber's finding that between the days immediately preceding 11 July 1995 and at least October 1995, the Srebrenica JCE existed with the primary purpose of eliminating Bosnian Muslims in Srebrenica by killing the men and boys and forcibly removing the women, young children, and some elderly men. The trial chamber concluded that the objective of the Srebrenica JCE involved the commission of crimes of persecution and inhumane acts, forcible transfer. The trial chamber also concluded that by the morning of 12 July 1995, the crimes of genocide, extermination, and murder became part of the means to achieve the objective of the Srebrenica JCE. The trial chamber found that Mr. Mladić contributed significantly to the Srebrenica JCE and that he shared the intent to achieve common objectives. Under ground 5A of his appeal, Mr. Mladić challenges the trial chamber's findings that he was part of a common criminal plan to possibly transfer Bosnian Muslims and commit genocide, extermination, and murder. Regarding the common plan to possibly transfer Bosnian Muslims, the appeals chamber, Judge Nyambe dissenting, finds unconvincing Mr. Mladić's submission that he was acting to evacuate civilians for humanitarian reasons. The appeals chamber finds Judge Nyambe dissenting that he demonstrates no error in the trial chamber's conclusions that the civilians who left Srebrenica in July 1995 did not have a genuine choice but to have to leave, that their displacement was not lawful, and that the removal of Bosnian Muslim women, young children, some elderly men from Srebrenica was possible. In this regard, the appeals chamber finds Judge Nyambe dissenting that Mr. Mladić fails to demonstrate to undermine the core findings of the, to undermine the core findings relied upon by the trial chamber, including that it was the conduct of the VRS that precipitated the humanitarian crisis that preceded the displacement, as well as the violent nature with which the VRS affected the displacement. In view of the above, the appeals chamber finds that Nyambe dissenting that Mr. Mladić fails to demonstrate that the trial chamber erred with respect to Srebrenica JCE in finding that the removal of Bosnian Muslim women, children, and some elderly men from Srebrenica was possible. As explained in the judgment, the appeals chamber finds Judge Nyambe dissenting that Mr. Mladić demonstrated no error in the trial chamber's assessment of evidence in relation to his participation in the common criminal plan to commit genocide, extermination, and murder. Consequently, the appeals chamber, Judge Nyambe dissenting, dismisses ground 5A of Mr. Mladić's appeal. The appeals chamber, Judge Nyambe dissenting, further rejects Mr. Mladić's arguments under ground 5B of his appeal that in concluding that he significantly contributed to the Srebrenica JCE, the trial chamber failed to give sufficient weight to 1. Evidence regarding his absence from Srebrenica. 2. Evidence that the MOOC was not under his effective control. 3. the military context and content of orders he gave in Srebrenica. 4. Evidence undermining the authenticity and reliability of certain intercept communications. And 5. Evidence regarding his knowledge of the crimes, his inability to punish crimes, and that he or his subordinates prosecuted or investigated crimes. In particular, with respect to his absence from Srebrenica in July 1995, the appeals chamber notes that the trial chamber's finding that Mr. Mladić remained in command and control of the VRS gave orders to VRS units that were implemented and communicated over the phone on a regular basis with the VRS main staff and his subordinates. The appeals chamber finds Judge Nyambe dissenting that his arguments challenging the trial chamber's weighing of evidence in this regard reflect mere disagreement without demonstrating any error. For these reasons, and other reasons elaborated in the judgment, the appeals chamber, Judge Nyambe dissenting, dismisses ground 5B of Mr. Mladić's appeal. Under ground 5D of his appeal, Mr. Mladić challenges the trial chamber's finding that he shared the intent to achieve the common purpose objective of the Srebrenica JCE. The appeals chamber finds that Nyambe dissenting that Mr. Mladić fails to demonstrate that the trial chamber erred by giving insufficient weight to 1. His statements and actions to adhere to international law and ensuring the welfare of prisoners of war. 2. The military context of the orders he gave and his subordinates gave in Srebrenica, which he contended were consistent with combat operations. In particular, with respect to the order he issued on 13th July 1995, which called for the prevention of the entry of local and foreign journalists into the zones of combat operation in Srebrenica and Jepa, as well as a ban on giving any information to the media about operations in Srebrenica. The appeals chamber notes, Judge Nyambe dissenting, that Mr. Mladić attempts to show that this order was aimed at preventing access to Srebrenica for the media's own protection and to prevent the spreading of rumors. Mr. Mladić ignores, however, that the trial chamber's finding on this shared intent is based on a number of other findings regarding his position, his presence on the ground in Chari, and involvement in the Hotel Fontana meetings, his proposal to mislead the international public about the truth at the 16th Assembly session, and the burials of Muslim and Muslims, men and boys, murdered in Srebrenica. Based on the foregoing and other reasons set out in the judgment, the appeals chamber, Judge Nyambe dissenting, dismisses ground 5B of Mr. Mladić's appeal. For the reasons set out in the judgment, the appeals chamber, Judge Nyambe dissenting, dismisses ground 5E of Mr. Mladić's appeal, under which he argues, inter alia, that the trial chamber failed to provide a reasoned opinion of evaluate the military status of the victims. With respect to Mr. Mladić's challenge under ground 5.1 of his appeal, the appeals chamber considers, for the reasons set out in the judgment, Judge Nyambe dissenting, that he fails to show any error in the trial chamber's reliance on evidence and adjudicated facts in reaching its findings relating to the Srebrenica JCE. The appeals chamber, Judge Nyambe dissenting, dismisses ground 5.1 of Mr. Mladić's appeal. E. Hostage taking JCE. The appeals chamber recalls the trial chamber's finding that from around 25 May 1995 and until approximately 24 June 1995, the hostage-taking JCE existed with the common objective of capturing UN personnel deployed in various parts of Bosnia and Herzegovina and detaining them at strategic military locations to prevent NATO from launching airstrikes against Bosnian Serb-held targets. The trial chamber further found that Mr. Mladić, as commander of the VRS main staff, was closely involved throughout every stage of the hostage taking and significantly contributed to and shared the intent to achieve the common objective of the joint criminal enterprise. In relation to Mr. Mladić's challenges under ground 6A and 6B of his appeal, the appeals chamber finds that Mr. Mladić fails to demonstrate that the trial chamber aided in finding that it had jurisdiction over the hostage taking of UN personnel, or that there are cogent reasons to depart from well-established jurisprudence on this matter. The appeals chamber recalls that under Common Article 3 of the Geneva Convention, there is an absolute prohibition of taking hostages of any person not taking part in hostilities, including detained individuals, irrespective of their status. Irrespective of their status prior to detention. Mr. Mladić therefore fails to demonstrate that the trial chamber aided in finding that the status of the UN personnel as combatants or civilians was irrelevant to determining whether they were entitled to protection against hostage taking under Common Article 3. The appeals chamber therefore dismisses ground 6A, 6B of Mr. Mladić's appeal. Mr. Mladić also demonstrates in ground 6C of his appeal that the trial chamber gave insufficient weight to exculpatory evidence on his significant contribution and shared intent in relation to the hostage-taking JCE. In particular, Mr. Mladić does not show how selective orders to treat the detained UN personnel as prisoners of war, examples of alleged favorable treatment of the detainees who were threatened, abused, used as human shields, could undermine the trial chamber's conclusion that he significantly contributed to the hostage-taking JCE. Similarly, the appeals chamber finds that Mr. Mladić's argument that his orders to detain and disarm the UN personnel, as well as those forbidding leakages of information regarding detention and contact with the detainees, were lawful, failed to identify any error to undermine the trial chamber's finding that he significantly contributed to the hostage-taking JCE. Furthermore, in light of the evidence and the trial chamber's finding that Mr. Mladić issued orders to detain the UN personnel and present and place them at potential NATO airstrike locations, made statements on the fate of their detainees, informed AMPROFO that their release was contingent on the cessation of airstrikes and that his subordinates threatened the UN personnel with the aim of stopping the airstrikes. The appeals chamber finds that Mr. Mladić fails to demonstrate that the trial chamber insufficiently considered his alleged proactive actions and conduct in finding that he shared the intent to achieve the common purpose of the hostage-taking JCE. For the foregoing reasons, the appeals chamber dismisses ground 6C of Mr. Mladić's appeal. F. modes of liability. The trial chamber convicted Mr. Mladić under Article 7.1 of the ICTY Statute for his commission of crimes through participation in 4 joint criminal enterprises. The trial chamber stated that Mr. Mladić's conduct and superior position were encapsulated within the conduct relied upon in his participation in the 4 joint criminal enterprises. When determining Mr. Mladić's sentence, the trial chamber took into account his participation in the 4 joint criminal enterprises in his capacity as commander of the VRS main staff, finding that it amounted to an abuse of his superior position. Under ground 7 of his appeal, Mr. Mladić submits that the trial chamber erred by failing to provide a reasoned opinion in its findings on his superior responsibility and established his liability under Article 7.3 of the ICTY Statute beyond reasonable doubt. The appeals chamber considers that the trial chamber's statement that Mr. Mladić's superior responsibility was encapsulated within his joint criminal enterprise liability falls short of a reasoned opinion. Notwithstanding, the appeals chamber considers, Judge Nyambe dissenting, that Mr. Mladić confuses superior responsibility under Article 7.3 of the ICTY with abuse of authority as an aggravating factor in sentencing, which does not require a finding of superior responsibility. The appeals chamber, Judge Nyambe dissenting, therefore dismisses Mr. Mladić's argument that the trial chamber should have made findings on the elements of Article 7.3 of the ICTY Statute in order to consider his abuse of authority as an aggravating factor in sentencing. Based on the foregoing, the appeals chamber, Judge Nyambe dissenting, dismisses ground 7 of Mr. Mladić's appeal. G. Systematic unfairness or bias throughout the proceedings. Systematic unfairness or bias throughout the proceedings. Given that Mr. Mladić has failed to establish any error warranting the appeals chamber's intervention in respect of ground 1 to 8A up to B of his appeal, the appeals chamber finds, that Nyambe dissenting, that his request for a retrial or remittance to remedy cumulative errors in the trial judgments is without merit. The appeals chamber, Judge Nyambe dissenting, dismisses ground 8E of Mr. Mladić's appeal. Sentencing. The trial chamber sentenced Mr. Mladić to a single sentence of life imprisonment for 1. Genocide, 2. Persecution, extermination, murder, deportation, and inhumane acts as a crime against humanity, and 3. Murder, terror, unlawful attacks on civilians, and taking of hostages as a violation of the laws of war and customs of war. In relation to Mr. Mladić's challenges against the trial chamber's consideration in the determination of his sentence under ground 9 of his appeal, for reasons stated in the judgment, the appeals chamber finds, Judge Nyambe dissenting, no discerning error in the trial chamber's conclusion that Mr. Mladić abused his position of authority and that this added to the gravity of the crimes. The appeals chamber also finds, Judge Nyambe dissenting, that Mr. Mladić fails to demonstrate a discernible error in its assessment of circumstances mitigating his sentence. With regard to Mr. Mladić's submission that the trial chamber failed to give sufficient weight to his alleged benevolent treatment of and assistance to victims as mitigating factors, the appeals chamber recalls that the trial chamber noted the central position that Mr. Mladić held within the leadership of the PRS and considered that he had the power to provide assistance to the victimized populations on a large scale had he wanted to do so. The trial chamber further recalled the sporadic benevolent acts of ineffective assistance may be disregarded and therefore did not consider this factor in mitigation of Mr. Mladić's sentence. The appeals chamber considers, Judge Nyambe dissent, that in light of the gravity of the offenses committed by Mr. Mladić and the noted sporadic nature of the benevolent treatment and assistance undertaken by him, he does not demonstrate any discernible error in the trial chamber's assessment of his sentence as a mitigating circumstance. Furthermore, the appeals chamber considers, Judge Nyambe dissent, that the trial chamber properly took into account the general sentencing practices in the former Yugoslavia and finds, Judge Nyambe dissenting, that Mr. Mladić fails to demonstrate that the trial chamber erred in imposing a life sentence. Based on the foregoing, the appeals chamber, Judge Nyambe dissenting, dismisses ground 9A, 9B, 9C, 9D of Mr. Mladić's appeal. I now turn to the prosecution's appeal. Under ground 1 of the indictment, the prosecution alleged that between 31 March 1992 and 31st December 1992, Mr. Mladić committed in consort with others, planned, instigated, ordered, and/or aided and abetted genocide against a part of the Bosnian Muslim and/or Bosnian Croat groups as such in municipalities of Bosnia and Herzegovina, the Count 1 municipalities. The trial chamber found that a large number of Bosnian Muslims and/or Bosnian Croats in these communities were the victims of prohibited acts of genocide, such as killing or seriously bodily or mental harm, which contributed to the destruction of their groups. The trial chamber further found by majority that certain physical perpetrators of these prohibited acts had the intent to destroy a part of the Bosnian Muslim group when carrying out the prohibited acts in most of the Count 1 municipalities. However, the trial chamber was not convinced beyond reasonable doubt that these perpetrators intended to destroy the Bosnian Muslims in the Count 1 municipalities as a substantial part of the protected group. The trial chamber was also not convinced beyond reasonable doubt that the Bosnian Serb leadership possessed genocidal intent or that the crime of genocide formed a part of the objective of the overarching JCE. Accordingly, the trial chamber acquitted Mr. Mladić of genocide under Count 1 of the indictment. Under Ground 1 of this appeal, the prosecution argues that the trial chamber erroneously concluded that the Bosnian Muslim communities of the Count 1 municipalities did not each constitute a substantial part of the Bosnian Muslim group. In addressing this argument, the appeals chamber recalled that where a conviction for genocide relies on the intent to destroy a protected group, in part, the targeted part must be a substantial part of that group. In particular, the appeals chamber, Judge Ngam and Judge Penton dissenting, finds that the prosecution does not demonstrate error in the trial chamber's conclusion that the Bosnian Muslim communities of the Count 1 municipalities each formed a relatively small part of the group. With respect to the prosecution's contention that the destruction of the Bosnian Muslim communities of the Count 1 municipalities would in each case have been significant enough to have an impact on the Bosnian Muslim group as a whole, the appeals chamber recalled that it is not just any impact on a protected group that supports a finding of genocidal intent. Rather, it is the impact that the destruction of the targeted part will have on the overall survival of that group, which indicates whether there is intent to destroy a substantial part thereof. The appeals chamber, Judges Ngam and Penton dissenting, finds that with respect to the Bosnian Muslim communities of the Count 1 municipalities, neither the trial chamber's finding nor the evidence referred to by the prosecution reflects such a threat to the viability or survival of the Bosnian Muslim group as a whole. The appeals chamber, Judges Ngam and Penton dissenting, therefore finds that the prosecution fails to demonstrate that the trial chamber erred in concluding that the Bosnian Muslim communities of the Count 1 municipalities did not each constitute a substantial part of the Bosnian group in Bosnia and Herzegovina. The appeals chamber, Judge Ngam and Penton dissenting, dismisses ground 1 of the prosecution's appeal. Under ground 2 of this appeal, the prosecution submits that the trial chamber erred in concluding that the genocide did not form part of the common purpose of the overarching JCE by failing to infer the destructive intent of Mr. Mladić and other overarching JCE members, and by applying a heightened evidentiary threshold in its assessment thereof. The appeals chamber recalls, however, that a substantiality assessment considers the impact that the destruction of the targeted part will have on the overall survival of that group. Noting that the Bosnian Muslim communities of the Count 1 communities collectively comprised approximately 6.7% of the Bosnian Muslim group, the appeals chamber, Judge Ngam and Judge Penton dissenting, considers that a reasonable trier of fact could reasonably have concluded that these communities, individually as well as cumulative, formed a relatively small part thereof. The appeals chamber, Judge Ngam and Judge Penton dissenting, therefore, concluded that a reasonable trier of fact could also have found that the destruction of the Bosnian Muslim communities of the Count 1 municipalities, individually as well as cumulatively, was not sufficiently substantial to have an impact on the group's overall survival at the relevant time. Recalling that the appeals chamber will only review alleged errors that have the potential to affect the outcome of an appeal, the appeals chamber need not address the prosecution's remaining arguments and remedial requests in relation to the trial chamber's alleged failure to infer Mr. Mladić's intent and convict him of genocide under count 1 of the indictment. Based on the foregoing, the appeals chamber, Judge Ngam and Judge Penton dissenting, dismisses ground 2 of the prosecution's appeal. Mr. Mladić, please stand while I read the full text of the disposition, the appeals chamber. For the foregoing reasons, the appeals chamber, pursuant to Article 23 of the statute and Rule 144 of the rules, noting the written submissions of the parties and their oral arguments presented at the appeal hearing on 25 and 26 August 2020, sitting in open session, dismisses Mr. Mladić's appeal in its entirety, Judge Nyambe dissenting, as to grounds 1, 2, 3, 4, 5, 7, 8, and 9 of Mr. Mladić's appeal. Dismisses Judge Ngam and Judge Patton dissenting the prosecution's appeal in its entirety. Affirms Judge Ngam and Judge Patton dissenting the disposition of the trial chamber, finding that Mr. Mladić is not guilty of genocide under count 1 of the indictment. Affirms the disposition of the trial chamber, finding Mr. Mladić of taking hostages as a violation of the laws or customs of war under count 11 of the indictment, pursuant to Article 71 of the ICTY Statute. And further, affirms Judge Nyambe dissenting the disposition of the trial chamber, finding Mr. Mladić guilty of genocide under count of the indictment, persecution as a crime against humanity, count 3 of the indictment, extermination as a crime against humanity under count 4 of the indictment, murder as a crime against humanity under count 5 of the indictment, as a violation of the laws or customs of war under count 6 of the indictment, deportation as a crime against humanity under count 7 of the indictment, inhumane act, forcible transfer as a crime against humanity under count 8 of the indictment, terror as a violation of the laws or customs of war under count 9 of the indictment, unlawful acts on civilians as a violation of the laws or customs of war under count 10 of the indictment, pursuant to Article 71 of the ICTY Statute. Affirms Judge Nyambe dissenting the sentence of life in prison imposed on Mr. Mladić by the trial chamber, rules that this judgment shall be enforced immediately pursuant to Rule 145A of the rules, and orders that in accordance with Rule 127C and 133 of the rules, Mr. Mladić shall remain in the custody of the mechanism pending the finalization of the arrangements for his transfer to the state where he will serve his sentence. Judge Priska Nyambe appends a partial dissenting opinion. Judge Aminata Ngam and Judge Seymour Penton append a partial dissenting opinion. Mr. Mladić, you may be seated. Registrar, please distribute copies of the written judgment to the parties after we rise. This concludes the appeal proceedings in this case.
Your Honor, I apologize for the interruption. I just have a small housekeeping matter. I just wanted to ask that the record also reflects the appearances of the prosecution, Barbara Goy, Laurel Baig, Amir Zeds, and our case manager, Janet Stewart. Thank you very much.
Noted. Registrar?
Yes, Your Honor, the judgment will be distributed now.
All rise.
All rise, vous voulez.